Hello, today we talk about 5 must-do actions before you file a non-provisional patent application. So the first thing you should do is to conduct a thorough prior art analysis, and that way you know exactly what is coming up, and oftentimes your search may be better than what is done by the patent office. And if the best prior art is already in front of the examiner, it will be considered, and of course it will simplify your path when you enforce your patent, because people can't locate additional prior art to bring the patent in question. So therefore, before filing the application, you should conduct a thorough search of existing patents and publications to ensure that the invention is novel and non-obvious. The second thing to do is to be familiar with the patent system and guidelines. And so by being familiar with the process, you will know exactly what's coming at you. So for example, when you file a patent application, that doesn't mean you're going to get allowed it right away. Typically, you should expect to be pushed back by the patent office as to why your invention is novel and not obvious. And of course, when you know that, then you should also know the proper actions to respond to a rejection. And that is, you should be seeking to communicate with the examiner and take the opportunity to show why your invention is worthy of a patent. Many people only respond to a rejection in writing, and by doing that they miss out this communication factor and the ability to build a relationship with the examiner, and a lot of time that will make the examination process smoother and you can get your patent earlier. So if you know that what's coming at you from the patent office and also the appropriate way to respond, it'll shorten your trip through the patent office and you'll get your patents earlier. The third thing to consider is to protect your early experimentations with a provisional patent application. So a provisional application, in contrast to a non-provisional patent application, is a type of informal document that you can file as a placeholder with the patent office, and they will give you a protection for 1 year period before it expires automatically. Now, if you have a provisional in place, then you can go and talk to people without fear of being copied or without fear that it might invalidate your subsequent patent. Because as long as you have that early priority date, you can talk to them, you can sell you can pre-sell your product, you can do Kickstarter, and nothing will affect your your patent application. In many countries, such as let me go back. In the US, we have a grace period of 1 year from any public disclosure to file a patent application. However, that grace period is not available in other jurisdictions. So for example, if you're in China or you're in Europe and you do that, all your patent rights have been lost. So the short of this is, when you file a provisional application, there are many advantages. Number one, low cost. If you can't get a lawyer to help you draft a provisional in as complete detail as you can, collect any document you have and submit that as a provisional and get something in place. The best thing to do is if your provisional is identical to your non-provisional, because when you convert, there won't be any question of why is a non-provisional having additional subject matter that's never disclosed by the provisional. But if you don't have that luxury to work with a professional in turning that in doing a proper provisional application, then just grab any documentation you have, file a provisional, and get at least some protection in place. And the last point we want to make is you should consider using a belt and suspender approach. So even if you have a provisional application file and that's even converted into a non-provisional, you should still consider the use of non-disclosure agreements, or NDAs, or confidentiality agreement as they're called. When you use a belt and suspender approach like that, you ensure maximum protection of your idea. And so those are a few ideas for you to incorporate in your in your business journey, from inventing and then protecting your invention and going to the market with that. And we wish you success with your venture.